And I'm very delighted here to have my partner, David Downing, who's going to be presenting along with his other partner, Melissa. So I will go ahead and let them take over the stage. And I will also be here. So if you guys have any questions, comments, go ahead, unmute yourself, ask away. And I'll be also checking onto the comments for any questions.
All right. Good morning, everyone. And yes, thank you very much for being patient. Apparently, we have some rather big traffic emergencies, and we had a 5.1 earthquake this morning. So a lot of the in-person people were a little bit delayed. I've got to start off with the obligatory legal disclaimer. This is being presented for education purposes. For those of you where we are not your attorneys of record, we aren't your attorneys of record. And so we cannot provide you legal advice, but we can educate you about some of the issues and the laws and how things go along. This is intended to be interactive. So if you do have questions along the way, feel free to put them in the chat or speak up in the room. And that'll make things more interesting and also more relevant to your lives. And then we can discuss some of the issues that arise from real life examples, but just for the obligatory disclaimer purposes, we can't give actual legal advice. That said, my name's David Downing. I'm a partner here at Perlman Brown & Wax. We are an employment and workers' comp defense firm. I've been doing workers' comp defense only. I've never done the applicant side, so I am one of the white hats. And I've been doing this for about 13 years. This is Melissa here.
Good morning. My name is Melissa Manger, as David noted, and I'm Senior Associate here at Perlman Brown & Wax. And I have also only been a defense attorney looking for workers' compensation insurance carriers, third-party administrators, and some employers as well. And we are very excited to be speaking to you today. A little background on myself. I do a lot of plans with very heavy employer-involved accounts. And some of those include construction companies, also site-specific owner-controlled insurance programs involving union employees, as well as the myriad of other companies, very diverse portfolio, I guess, for all of us here at Perlman Brown & Wax.
Yeah. And I have, over the years, specialized in staffing agencies, PEOs, and other types of joint employment or statutory employment situations. We've done a lot of gig work cases. And then also, as Melissa mentioned, other industries like construction and entertainment where people are working all sorts of jobs everywhere, and it's just a nightmare figuring out who's actually on the hook. So we come from a perspective of those specific industries, and those are also very prone to injury and prone to abuse, which is where we're going to focus today. Everybody here is from the broker or employer side, so we're going to be focusing not so much on the law, but on practical things that you can do in your business to affect your bottom line, to help us as the defense attorneys actually defend your interests instead of just managing the claim from a claims perspective, which is what we get stuck doing a lot in our job, but it's not what we like. The insurance company, it's $1 trillion company, and it's not their money, it's your money. And so we like the opportunity to represent you and help you save money, because that's a real benefit instead of just looking at the actuarial tables from the insurance company's side, which is important too, but today's about the employer. So I will be talking about some practical things that you can do both to prevent claims being filed in the first place, to discourage claims or runaway claims where one employee gets injured and then they refer their friends from work to their attorney and then everybody all of a sudden is injured. And then the classic post-termination CTs, fraud claims and things of that nature that are so difficult to deal with. Melissa's going to be interrupting me so that you don't get bored of my voice throughout. And as we said, if you have questions, just drop them in the chat and we will address them as soon as we notice them. So first, I will talk to you a little bit about why we lose. In workers' comp, especially in workers' comp defense, in early training, one of the things I tell my attorneys that come in the door is, if you want to go out there, fight, and win cases, get out of workers' comp, because that's not what we do. We're not here to win. We're here to lose less, which is a pithy way of setting expectations that the standard that we have to prove is literally impossible. We are requested by the courts to prove a negative, which is a logical fallacy, and it's impossible to do. You can't ever prove that something didn't happen, but you can prove things around that. It's just really hard. And usually by the time a case gets to the defense attorney, everything's already set. The evidence is gone or it's old, and the adjusters have already set up the basis of the claim. The treatment's already underway. And, if mistakes have been made or evidence lost, it's too late. And sometimes it's a year into a claim before an attorney ever actually looks at it. So one of the things that you can do is inspire your claims professionals to get the attorneys involved early. The earlier, the better. Some of my top clients on the staffing agency side, Partners Personnel is my favorite. They are so good at this. They get claims out to me within a week of the date of injury. And so we have, from the very beginning, all the information is fresh on everybody's mind. Then they also have a lot of other things that they have in place, procedures, both before and after a claim, that we're going to steal a couple of ideas from them, as well as other things that we've seen from the employer side that work out really well. But first, a little bit of boring law. The reason why employers always lose in California is because of Labor Code Section 3202. It says that the court is to liberally construe the entire code in favor of the employee, which over the years has been expanded into essentially a presumption that they have been injured. And while it isn't a formal presumption, they still have a burden of proof that they have to establish. All they have to do to establish that is stand up in front of the court and say, I worked and I feel pain. And then get a doctor to say they have pain. And then now you have a compensable claim. That's literally all it takes, which is insane. In any other field of law, that would not be anywhere close to enough to establish a preponderance of the evidence. But because the code specifically instructs the court to liberally construe the laws in favor of the applicants, the employees, that's enough. And so how do we combat that? When there's almost a presumption that if someone works, they are injured, how do we combat it? We have to compile evidence that they're not injured, which can only be obtained before they're mad at you. So the things we're going to cover today are what you do before, what you do during, and to a certain extent, what you do after a claim is filed. The first thing being before. There's a lot of things that we can do in advance, and a couple misconceptions that I want to break. We see a lot of employers that seem to think if they downplay a report of pain, or if they tell the employee, well, let's not report the claim, let's send you to the doctor, and we'll pay for it out of pocket, and we'll take care of you. They think that that's doing the right thing, or that's being kind to the employee and taking care of them, but it's shooting yourself in the foot. There's a procedure in place that the courts require. The law requires that we do certain things in terms of notices. And those are all in place to protect the employee. So it makes sense that if we do that, then it's going to be in their favor. It's going to be encouraging them to file a claim. But you have to remember, most injuries are bumps and bruises. Somebody falls down. how many times do you fall down in your private life and you get back up and, if you're an old guy like me, then you feel the pain the next day, but in a week it's gone. That's what most of these injuries are. And it doesn't become litigated. It doesn't start hitting your profit line, and it doesn't start hitting your XMOD until somebody gets annoyed and approached by an applicant's attorney. That's when.
Sorry,
please.
First interjection of the day. I also just want to highlight that a lot of the time when we're looking at the notes in a particular claim or case file, it'll say certain comments, before we get involved, before something gets litigated. And for example, a claims adjuster will be speaking with the injured worker as they're required to investigate the claim, and they will say some kind of comment indicating that they don't feel as though their supervisor or whomever at the job site was taking their complaints seriously. They were brushed off, and essentially they felt like they weren't heard. And a big thing to highlight is communication, and to have empathy, and to also, investigate something and speak with the injured worker as soon as possible and get down their statement.
Right. We do see that all the time. And in many cases, in fact, I have even heard in deposition, if somebody were to just have told me they were sorry and checked in on me, I never would have felt the need to go litigate my claim or go to a doctor. I just felt ignored and felt like they didn't care about me.
Yeah.
We see that all the time. So what you can do is make sure that you have all of your proper procedures set up in advance and that you follow them very, very tightly. And that begins on the day of hire. And this is both to avoid claims in the beginning and also to give us ammunition for those post-term claims and the fraudulent claims that plague us all. So when you hire someone, there are some things that you're required to do, including giving them notice of how to file a claim. There's the posters that we all have to place in the break rooms. There is the MPN notice that you provide them when they're hired for identifying the medical network. And there's also the notice of how to report the claims that has to be given to them. Some companies, especially in the construction industry, they're required to do additional training sessions for safety that OSHA requires. And so for those training sessions, they provide actual instructions, and we get a little quiz that the applicants or the employees take at the end, showing that they understand when to file a claim, when to report the claim, how to report the claim, how to request medical treatment. And if you give them all of that information and all of that safety training in the beginning and document it in their file, we can prove that they knew. And that's important. Why is it important? In a post-term claim, it comes down to knowledge, and it comes down to when was the injury reported. The employees always say, well, I told my supervisor, I told him I was in pain, I told him I fell down. And that's not technically a report of injury. But if it's liberally construed, we lose. If we can show they were given training sessions and safety meetings twice a year, 4 times a year, or even just right at the beginning of their employment, and they filled out this form that said that they understood how to report an injury and that they needed to request medical treatment in order for it to be a report of injury, then we can prove that they knew how to do it. And then they didn't. With that proof, we can get a long way. Does it make us win? Not necessarily, but it gets us part of the way.
I was just going to mention in regard to the posters as well, and kind of to highlight how difficult it can be to be in the employer's position and the risk of litigation. There actually was AB 1870 that is to take effect January 1, 2025. And that is requiring employers to include in their posters a specific language that indicates that an injured worker has the right to speak with a licensed attorney regarding their workers' comp rights. And obviously, taking that to its logical conclusion can show that this will incentivize litigation, even though perhaps a injured worker would not have otherwise consulted or spoken with an attorney. It just puts that, that much more into their mind when something like this happens.
Right. But again, compliance is necessary. Both it's illegal not to comply, but also it actually does help the employers. Nobody reads those posters in the break room. Nobody reads. Most of them don't even know it's there because it just becomes part of the background. So a little caption on the bottom of the poster that says you have to consult an attorney. It's a legal compliance thing, like the choking hazard on your pillow. Everything's a choking hazard, but nobody's going to try and swallow a pillow. Lawyers are the worst. I'm sorry. I apologize for all of us. It's all our fault. But these kinds of disclaimers, this is why they have to put those things on the posters. But complying with the poster regulations, it's not going to help you. It's not going to hurt you. From a work comp defense standpoint, from an employment law standpoint, totally different. You have to comply.
Obviously speak with your HR department regarding compliance and posters and whatnot, and also your legal department, employment law department, etc.
Right. And there's a lot of different OSHA posters out there. Melissa actually showed me a picture of one the other day that showed a guy in handcuffs and said workers' comp fraud is bad. I don't know if that creates the work environment that we really want, but it's comical and it's an OSHA approved poster.
We're not showing it today.
No. And that gets back to the environment that you want to convey to your employees. It's disgruntled employees that file fraudulent claims. It's people that remember, hey, I bumped my toe a month ago, and now I'm mad at my supervisor, and so they go get another job and file a claim. That's what leads to all this fraud in the post-term CTs. And so if we can take care of our people, we can show the empathy when they tell us, I'm feeling pain in my back. Well, I'm sorry, sir, but you're 63. Of course you are feeling pain in your back. And that's not a report of claim. But the empathy of, are you okay? Do you need to go to a doctor? Do you need to take a break? Do you need to take a day off? That all helps. And in the case of slip and falls, accidents, things like that happen that probably aren't real legitimate actual injuries requiring medical treatment leading to permanent disability, those kinds of things, when they first happen, the employee is embarrassed and they are wanting to downplay their injury, which is the perfect time to get them to write down everything that happened, to present them with a claim form, to give them a incident report where they write down what happened, what hurt, what body parts, and all of those things that really help us in litigation a year, 2 years down the line, help us with being able to prove what actually happened instead of what the applicant's attorney has coached their client to say happened. Because we have, in the employee's own words, often and even better in their own handwriting, in a document that they signed and dated on the date of injury, this is what happened. These are the things that hurt. And they write it down in their language of choice. And they're given, in some cases, even a body diagram, which is fantastic. We love seeing that from a defense standpoint, to be able to ask them in a deposition or have a legal doctor ask them, what body parts hurt you immediately after? And of course they say, well, my skin and everything inside of it. But if we have the employee's own statement, I fell down and I bumped my left knee, and then a picture of a body, and they circle their left knee and they do little slash lines on it for pain, and then they sign it and they date it in their own handwriting. How are they going to go back on that? But if I don't have that, I can never prove what they were feeling because pain is subjective and it can't ever be proved medically or factually. But with their own words, their own writing, and a nice, pretty little picture with a circle on it, now all of a sudden we've locked them in to left knee only. Does that mean that conclusively the claim is going to remain at left knee only? Of course it doesn't, because attorneys are awful and they abuse the system and they know how to tweak things and they know how to get doctors and they know how to make excuses. So things will still spiral out of control. But the more that we have and the earlier that we have it, the more we can protect you. Now that's obviously for claims that are reported. What about claims that weren't reported? The post-term CT or the ones that were completely fabricated. We have all these fun stories from litigation over the years of accidental evidence that we've stumbled across that proves something didn't happen. I had a case early in my career where it was a big warehouse and they were dealing with a lot of product, so there were surveillance cameras everywhere. And this one very clever individual figured, well, there's no cameras in the bathroom, which of course there weren't. But there was in the hallway leading to the bathroom, and apparently the employee didn't think there would be. So we have a nice little video showing the employee walking into the hallroom, looking through the hallway window door, and making sure no one's coming, bending down carefully to bunch up the floor mat, and then gently lying down on the ground, and then starting to roll around and writhe in pain. And seconds later, people come running into the hallway. Oh no, are you okay? Are you okay? Help him up, all of this. And it's all in the video. We didn't get that video until a year and a half into the litigation when we'd already incurred a lot of expenses. And then the employer says, oh, hey, I have this video. And then all of a sudden we win. The case goes away because that is actually conclusive evidence. Now, are we going to have that very often? No. In 13 years of litigation, I've only seen it once. But the things that we can do to help generate that kind of thing, if you have surveillance cameras, make sure that you secure those as soon as you know about a claim, as soon as you get a claim reported. Now, if it's 10 months ago, you probably don't have that video footage anymore, and that's okay. There's nothing we can do about it. But if it was a week ago, maybe you do. If it's a reported claim that we question, better chance that you probably do, because then it's going to be within a day or two. So surveillance video footage for staffing agencies, that can be very challenging because it isn't your facility. You don't have control over those kinds of things. And so keeping that relationship with the work location. And we see, especially with staffing agencies, sometimes there's a little bit of contention there because the work site location doesn't want to generate a premises liability claim on their behalf. But in workers' comp, there is no such thing. The liability falls on the statutory employer, the general employer, or the staffing agency in those cases. And so there wouldn't be any premises liability there unless it's gross negligence. But the evidence like surveillance footage is something that we can do, but that's kind of a luck thing. Let's talk about things that everybody could do.
And just to comment really quickly on things that can assist, and for example, with a specific incident, even having things kept in your records, like payroll records. Everyone should have that, and it'll show when an employee came to work, when they signed in, signed out, or if they were to request time off. For example, an employee tells you that, on this day I slipped and fell, and you look at your payroll records and they weren't even working that day. In fact, they actually sent a time off request that says that they are going on vacation with their family and they will be gone for 3 days. And simple things like that are very important, but sometimes those things aren't in a file for one reason or another. And there are multiple requests for certain documents, and unfortunately, for one reason or another, they don't get to us for quite a while. And again, to David's point earlier, it's after we've already incurred substantial litigation costs in defense of the claim.
Right. And so those those documents that you compile early, the day of the injury, or in cases of post-termination CTs and fraudulent claims, the periodic records that you keep as a matter of course. You build it into your procedure. One of the favorite things that I've seen an employer do is, again, with the staffing agency, the employees are working at various different factories and manufacturing warehouses, things like that. They go to the staffing agency to pick up their paycheck every 2 weeks. And when they go, the staffing agency has them sign a form that says, I picked up my paycheck. Then they got a string of fraudulent claims and post-term claims, and a whole bunch of their employees started saying, well, we told them that we were feeling pain, that we were injured, and they didn't do anything about it. They didn't send us to the doctor. They just made us go back to work. And we were afraid to complain because I couldn't lose my job. So what they did, which is brilliant, and I love it, and I recommend it all the time, they added to that payroll form a questionnaire. Just 3 questions. Have you been injured? Are you feeling any pain that gets in the way of doing your job? Do you feel physically capable of doing all of your regular work duties? That right there. We get that form signed every 2 weeks saying, I'm not injured, I haven't been injured, I'm not feeling any pain and don't need medical treatment, and I feel capable of performing all my usual and customary job duties. And we have that signed in their language of choice every 2 weeks. How can they then come back later and say, well, I was feeling pain for 6 months and I told them and they didn't do anything about it? Well, no, that's not true, because they asked you every 2 weeks and you said no every single time. That helps. There's other times when we can do that as well, and some of these are industry specific, so if you're outside these industries, I apologize. But a lot of staffing agencies do set temporary employments, and because they don't want to get into employment law claims, they usually keep the employees on the books, so they're still an employee. You don't need to do that. If it's a temporary assignment and you communicate to the employee that the assignment is only for 1 month or only for 6 months, and then it ends at that point, you can terminate them without worry that they're going to file a wrongful termination claim, because it was temporary from the beginning and you told them it was only 6 months. And in doing so, that isn't a contract of employment. It's not a guarantee that the temporary assignment is going to go the full 6 months. And some of my more astute staffing agencies that we work with, they have a notice of temporary assignment form that they give to the applicant even before they're actually placed, when they sign up with the company. And that says you will be given temporary assignments from time to time with specific periods or non-specific periods, and none of them are to be construed as guarantees of periods of time of employment. That covers you from an employment law perspective, but of course, if you're going to implement these forms, check with your HR people, check with your employment law people before you use it. Draft them up, have the attorneys look at it to make sure that it's phrased correctly to protect you, because we don't want to walk you into other issues. So before you implement any of these ideas, just make sure that you get your legal counsel to check it out and ratify it before you put it out into the field.
I have a question, David.
Yeah.
Does that also pertain to construction?
So I was going to hit that, because construction can be different. And with construction, it isn't temporary assignment, it's job assignment. And so that can be the same with tweaks. From an employment law perspective, regular employment, meaning you're hired, you work here, and it's at will, because we're California, it's an at-will state, and so it's not guaranteed, it's not contract, nothing like that. That is different from temporary employment. in an at-will state, it shouldn't be different because, you can get hired today and fired tomorrow for no reason at all. But because of all of the precautions that everyone takes for very good reason, and I'm not recommending that you stop taking precautions, with all of the forms and all of the HR onboarding documents that we do, it erodes a lot of the freedom of at-will. And you don't want to, in maintaining those freedoms, you're exposing yourself to so many other things that it's not worth it. So you could forego all of that and just be at will and be able to terminate people whenever you want willy-nilly, and just make sure that you don't ever tell them why you're doing it. But then you're not writing people up. You can't establish for cause. So unemployment insurance gets out of control. So there's a lot of issues with that. So we don't want to get into bolstering at will. It's not worth it. But the difference between just regular employment and temporary gives that temporary assignment a little bit more freedom to terminate and rehire. I have seen some staffing agencies which perhaps take it a little bit too far, where they will be at one assignment for a month, and then they get terminated, and then they get rehired, and then they're for another month, and then they get terminated and then rehired. Now, the court's going to look at that and realize that in reality, this is continued employment throughout, and they're not going to look at it at separate periods of employment. But if it's a different assignment, or if there's a gap of time between the assignments, even at the same location, then this is different employment, especially if there's a gap of more than a year. In construction, if you're hiring somebody for a specific job, there's a couple different layers of issues that come into play. First and foremost is independent contractor. Most construction companies do not understand the law behind independent contractor. In the last 3 years, the litigation of the case of independent contractors and the actual legislature came in and completely turned the law on independent contractor work on its ear, to the point where independent contractors in California, in all practicality, don't exist. There's so many restrictions on it. If you hire somebody that doesn't have their own incorporated business with workers' comp insurance and a contractor's license in whatever specialty that they're in, they are not an independent contractor unless you get extremely lucky. But more than 9 times out of 10, they are not an independent contractor. The plumber that you hire to come work one job and do one little thing, that is your employee for that day, unless that plumber owns his own business and has a license. So on the practical side, can every construction company require and only hire their contractors that have their own insurance and the licenses and all of that? That may be cost prohibitive in many, many situations. The big construction companies, the high rises and all of that, they still do it wrong all the time, but they're more careful about it. They have bigger budgets, so they can afford to make sure that they're hiring the licensed and insured companies. Bonded, even better. But you've got to be careful with those contractors that you bring in to do sub work. Because if they aren't insured, they are your employee. And you're going to get hit with that as the general contractor. And if that sub goes out and hires some guy off the street to dig a ditch for him, that guy's your employee too. Even though you didn't know him, you didn't pay him, and you didn't sanction him being hired. Because you hired the sub, he's your employee. So when you're doing these, you have to be very careful with who you hire. But then once you get past that hurdle, if you make sure that you have a written contract, it doesn't have to be more than a paragraph long, explaining what the job is that you are doing and the timeline that their contract is for to perform that one job, then that cuts off. It provides an end date. When they're done, they're not your employee anymore. And you don't have to terminate them formally like you would with a regular employee because you have the job contract documented. It also doesn't have to be a legally drafted contract. It can just be a work order. It's fine. It can be handwritten on an invoice saying this is the job that we're paying you for and the amount that we're paying you for it and when we're going to pay you, when it's complete. That's all you need. Freedoms, you're exposing yourself to so many other things that it's not worth it. So you could forego all of that and just be at will and be able to terminate people whenever you want willy-nilly and just make sure that you don't ever tell them why you're doing it. But then you're not writing people up. You can't establish for cause. So unemployment insurance gets out of control. So there's a lot of issues with that. So we don't want to get into bolstering at will. It's not worth it. But the difference between just regular employment and temporary gives that temporary assignment a little bit more freedom to terminate and rehire. I have seen some staffing agencies which perhaps take it a little bit too far, where they will be at one assignment for a month and then they get terminated and then they get rehired and then they're for another month and then they get terminated and then rehired. Now, the court's going to look at that and realize that in reality, this is continued employment throughout, and they're not going to look at it at separate periods of employment. But if it's a different assignment, or if there's a gap of time between the assignments, even at the same location, then this is different employment, especially if there's a gap of more than a year. In construction, if you're hiring somebody for a specific job, there's a couple different layers of issues that come into play. First and foremost is independent contractor. Most construction companies do not understand the law behind independent contractor. In the last 3 years, the litigation of the case of independent contractors and the actual legislature came in and completely turned the law on independent contractor work on its ear, to the point where independent contractors in California, in all practicality, don't exist. There's so many restrictions on it. If you hire somebody that doesn't have their own incorporated business with workers' comp insurance and a contractor's license in whatever specialty that they're in, they are not an independent contractor unless you get extremely lucky. But more than 9 times out of 10, they are not an independent contractor. The plumber that you hire to come work one job and do one little thing, that is your employee for that day, unless that plumber owns his own business and has a license. So on the practical side, can every construction company require and only hire their contractors that have their own insurance and the licenses and all of that? That may be cost prohibitive in many, many situations. The big construction companies, the high rises and all of that, they still do it wrong all the time, but they're more careful about it. They have bigger budgets, so they can afford to make sure that they're hiring the licensed and insured companies. Bonded, even better. But you've got to be careful with those contractors that you bring in to do sub work. Because if they aren't insured, they're your employee. And you're going to get hit with that as the general contractor. And if that sub goes out and hires some guy off the street to dig a ditch for him, that guy's your employee too. Even though you didn't know him, you didn't pay him, and you didn't sanction him being hired. Because you hired the sub, he's your employee. So when you're doing these, you have to be very careful with who you hire. But then once you get past that hurdle, if you make sure that you have a written contract, it doesn't have to be more than a paragraph long, explaining what the job is that you are doing and the timeline that their contract is for to perform that one job, then that cuts off It provides an end date. When they're done, they're not your employee anymore. And you don't have to terminate them formally like you would with a regular employee because you have the job contract documented. It also doesn't have to be a legally, drafted contract. It can just be a work order. It's fine. It can be handwritten on an invoice saying this is the job that we're paying you for and the amount that we're paying you for it and when we're going to pay you, when it's complete. That's all you need. So in those situations, yes, it is similar to temporary employment from staffing agencies in that it ends and it can restart. And you can also have a contractor or subcontractor who is employed with you on different projects overlapping at the same time, where you are essentially their employer 3 separate times. And if it's done properly and documented properly, it's 3 separate employments, even though it's all the same general contractor. So those kind of things can work too. And this does actually work in other industries. I see someone on Zoom who has building maintenance. In building maintenance, often you have people that are working on one building and then working on another building and then working on a third building, and they may be under different contracts for the company, where they're working for different business management companies, or they're just coming in under their own banner, I guess. And so if that is documented correctly, those can be separate employments as well if they're done on a contract basis. But if it's, for example, like ABM and Able and some of the big guys, they have all of their employees under their umbrella and they're sending them out to multiple different buildings, but it doesn't matter where they're working because they work for Able or whomever. And so that's a different situation because they've got so many people out in the field. But in any industry where you are sending people out for project work, the more you document that, the more it separates it out. So I'm sorry I went through a rabbit hole there, but that's one of my pet issues is these weird employment issues. So that's what you get. I'm kind of a workers' comp nerd, and if you get me going down a rabbit hole, I'm more than happy to. But when we get back to the issues of how to prevent these things in advance, coming up with these forms and questionnaires, asking the employees to document whether they are physically fit enough to continue doing the job, it does ride a little bit of a tight line where you can go too far and violate HIPAA, or you can walk the fence. And if you keep it in terms of asking if they are in need of medical treatment or if they have been injured, you're always allowed to ask them. If you ask them, do you have any medical conditions that would prevent you from lifting 50 pounds? That's too far. But if you ask them, are you in pain? Do you need to go to the doctor? Do you have an injury? Is there any reason why you can't keep working this next assignment? That's kosher. You can do that. So again, when you use these forms, when you have these questionnaires, make sure somebody looks at it before you put it into the field. But having those questions in place in advance before anybody's angry, before anybody's injured, can help us on the back end dispute what the employees are saying when they say, I'm injured, I felt pain, and the employer didn't do anything about it. Well, no, the employer did do something about it. In fact, they asked you if you were injured every 2 weeks, and you always said no. They made claim forms available to you every 2 weeks, and that protects you. When I've presented this before, I have gotten pushback but if we give them a claim form, aren't they going to fill it out just because? No, because in the moment, they're not angry. They're probably not actually injured or feeling pain. And they're not looking for that free vacation. They want to go back to work. They want to get that next assignment. And so they're going to sign the form, and they're going to downplay the injury that they have had, either because they're embarrassed or because it's a tough guy that just, I'm fine, I can keep working. And it's not until he's angry that he's not fine. So you get him to document everything when he's not angry. We have the next thing that I want to get into is the early investigation when something is reported. And that can be when an actual injury or an actual incident is reported, or when you first receive notice of that fraud claim or that post-term CT. When you do those things, that's when the employer has a brief opportunity to make a big impact in the litigation later. Because 6 months down the line, you've moved on, and all of the evidence that we need is gone. Unless it's payroll documents, but that doesn't help you in litigation. Unless it's like Melissa's example where they weren't working that day, but that doesn't happen that often. When you get a report of injury, whether it is post-term or directly from the employee while they're working, that's when everybody needs to jump into gear and do a full investigation. Have a questionnaire that they fill out, or if they're no longer there and it's post-term, that the supervisor fills out. Asking them specifically, did they ever ask for help or modification doing their job duties? Did they ever show that they were in pain? Did they ever mention anything in their personal lives? I got in an accident. I have a case in active litigation right now where we are pulling together the evidence because on the day of an alleged slip and fall, the applicant told her coworker, I fell at the bus station. And then 3 days later, that transformed into, I fell in the parking lot at work. Yeah. And then 6 months later, that turned into, I fell at work and I couldn't get up for an hour. I'm not exaggerating. That's how the mechanism of injury progressed. We knew from a supervisor's statement, I think I remember a coworker saying that she said she fell at a bus station. But that's all we had, is I think I remember. Then we got a little bit lucky. I asked her in the deposition, of course, did this happen? Of course, she denied it, and I can't prove it yet, so there's nothing to do there. We have the denial. But we put it in the record, and now she's denied it. Then the employer comes back and says, wait, we found the employee, and she remembers this. And she knows that the employee goes to this doctor because they go to the same doctor. That could have saved us a year of litigation if that had been secured at the beginning. I now have a medical report from the applicant's primary care physician that says I fell at the bus station. And I just got it a week ago. And so I'm still pretty excited to take that to court and see what happens. But it came late. And so we're already a year in, and I've already got a legal doctor that is saying that this was industrial because it happened at work. And I've already got a year's worth of primary treating physician telling us that this happened. And so I've got to turn the train around, which is a lot harder to do. Now it is going to be fun because I've got, smoking gun. We don't usually get that. But the importance of those kinds of statements as soon as humanly possible can save you, in this case, a whole year's worth of reserve. That's huge. And then we all know, once the case is settled, it's not over because we've got liens, we've got the EDD, and all of those reserves have to stay in place while we figure all that out. And the lien treaters out there, all they want to do is delay this because they know we don't want to litigate. They know we want to close the file. And so we pay them for the privilege of closing the file. If we get all this information early on, then we can save all of that. We can compel or leverage an early settlement for nuisance value, or we can run to court right in the beginning. Most of the cases that I have actually won at trial, I have gotten set for trial within 6 to 9 months after the claim was filed. Those are the cases that we win because we have the evidence right away and we can force it to trial before all the costs steamroll. Because you have to pay for all the discovery. You've got to pay for the subpoenas. You've got to pay for the doctors. You've got to pay for the QMEs. You've got to pay for me. You've got to pay for everything. And that includes depositions and all these things. We know they're going to lie at the deposition. If I can take a witness deposition in the beginning of a case, when I already know what that witness is going to say, we don't have to pay the applicant's attorney's fee for that deposition because it's our witness. And then we go straight to trial. In 6 to 9 months, we actually have the evidence, we can win. And then paired with all of the other documentation that we've done, if you give them the claim notices and all of the things that we recommend that you give them on the day they were hired and periodically throughout their employment, we have preserved statute of limitations. We have preserved any claims or disputes over what actually happened because you took a good report. We have rebutted the claims that the applicant is making about all the different body parts that they injured because you had them fill out a body diagram. None of this can be done by claims. It all has to be done by the employers. And the thing is that the employers don't know that they can do this because claims don't tell them. Because claims have a way that they do things, and they are, the good ones, are set up in order to protect you as best they can. But they're not protecting you. They're protecting everybody. And so it's just like, at the worst public schools, if there's one smart kid, that kid gets underserved because they're trying to make everybody pass the test. They're not trying to push every kid as far as they can go. And so the procedures that are set in place for the claims professionals and the third-party administrators are to make sure that nothing goes wrong. But they aren't really set up to make sure that everything goes right. Now, it's California workers' comp defense, and so nothing goes right because there's a presumption against us. But what we're trying to do with these kinds of education things is turn that around so that we can put some things in place with the employers that you can do, like the things we've discussed so far, to give us the ammunition to go out and fight. Because I can't prove someone isn't in pain unless I have a document that they signed that said they're not. I can't prove that they didn't fall unless I have a witness that watched them not fall. Or I have another witness that says, well, yeah, they said they fell, but they said they fell at the bus station. That's what the employer can do. I don't think I've maybe gotten one or two take-nothings that didn't involve an employer directly. Every now and then we get a little bit lucky. We find some subpoena records, or we get a doctor who just doesn't like the employee or doesn't believe them and washes them out. That happens, but there's no art, there's no skill in that. It's just luck. You get a good doctor and he doesn't believe them, and so great, wonderful, we win. But the ones that we fought, the ones that we really challenged, and the wins that we're proud of, every single one of those involved the employer being actively involved, and the earlier the better. Or the earlier, the cheaper. I don't know where we are on time. Looks like we're reaching that hour point. So Melissa, do you have anything to add before we open it up to questions?
Not particularly, just to highlight something that David was speaking about earlier, and getting statements from everyone and anyone who may have been working with the injured worker, and making sure that you get those and speak with their team. A lot of the times I'll see things where the injured worker is claiming that perhaps they were working by themselves, and then lo and behold, they have a team of 4 or 5 people assisting them, and then we speak with them and they give us the information that David was briefly highlighting earlier, like, I never heard so-and-so complaining, I never saw XYZ happen, I was with them on this day and that didn't happen, or we find out that it was a completely different story, and it's just that more helpful to us to defend the claim, and to also then have that information prior to taking a deposition, because it is extremely upsetting and frustrating when we find out those very big details after we had an opportunity to kind of get that really big impact in a deposition. Or even when we are trying to speak with, claims, even you guys, the employer, to explain our analysis on the case and all of the issues that we're seeing, but that would certainly change it and our entire litigation strategy when we have bits of information like that very early on, like David noted.
Right. And I did forget to mention one thing. You need to document everything, because if it's not documented, it didn't happen.
Yes.
Just like if it's not on the gram, didn't happen. Right? So if you give the employer a form and you don't document that you gave it to them, and they say, I never got that, how do I prove that? Well, we have another form that we give them, and they sign it saying, I acknowledge receipt of the DWC-1 claim form, the MPN notice, the intake form, the body diagram, the refusal of medical care, and they sign off on that, acknowledging that they received everything that you gave them at the time of hire, at the safety meeting, and when they report a claim. And then I can prove it. Or in a post-term claim, you mail it to them with a proof of service. The proof of service proves you served it. Now, in claims we hear all the time, there is actually a code section that says the mailbox rule. If we can prove that we put it in the mail, then that is conclusive, unless they can prove the negative that they didn't receive it, which of course they can't do because you can't prove negatives. But the court always believes the employee. So if the employee says, I didn't receive it, the court's going to believe them. But if you have a proof of service, the court has to acknowledge it. If you need a proof of service form, because that's not something that the employees normally do, you can get it from the DIR website. They have a form section and they have a sample proof of service in there. All you've got to do on there is fill out that form, write in what you served, when you served it, and who and where you served it to. Now, from you, it's mailed instead of served, but that works. We never see proofs of service from employers because that's not something that's legally required, but it helps. So document everything and put it in the file. And then give it to us. And then we can use it.
Actually, to touch on that, it is very nice when we get, for example, when we ask, the employer to hand us over the personnel file for an injured worker, and we get maybe 1 or 2 documents for one reason or another. It might be a job description, or it might just be, their initial application paperwork. But the actual personnel file itself comprises of so many additional other documents, and then all of a sudden we get, 187 pages, and this comes, 6 months later, and it's not really clear why that may have happened, but it's important that that we are going to have that for our assistance to defend the claim. And also too, we certainly are going to keep these documents, within our case file. A lot of the time we'll see subpoenas issued by applicant attorneys asking for a personnel file from an employer. And it's important that, we have the documents, but it doesn't mean that we're going to just freely give them to opposing counsel for one reason or another. And we certainly would discuss that with you prior to giving them any kind of documents. But, it's important for us to have it so that we know what's going on.
As I said before, we could go all day, and I do need to respect your time and end this.
Yep.
But that raises one last thing that I need to mention that will not take more than a minute. In California, the proper personnel file procedure includes 3 separately maintained files. There's the personnel file that includes all of the normal stuff that I'm sure your HR people are keeping in their personnel files. But there's 2 other files that many, many employers do not maintain that they should. A medical file, which is a HIPAA compliant file that is kept separate. And when an attorney subpoenas you asking for the personnel file, the HIPAA file doesn't go. And a management file, which contains all of the internal communications, emails, complaints, whining from the supervisors, and things from the employee complaining about their coworker who doesn't shower enough, or any of that. All those emails go into the management file, which also doesn't get produced when they ask or subpoena the personnel file, because it's a management file. It's separate. And if you keep them separate, they don't get wrapped up into the subpoena for the personnel file. But when your attorney asks for it, you give us everything. You give us the management file, and we find all sorts of mileage in there, all sorts of juicy little tidbits that we can use against the applicants in the depositions. And you give us the medical file because it identifies the doctor that put them off sick because they twisted their ankle walking their dog. And we can find those records that we would never be able to find otherwise.
And in terms of compliance with the
issues that he's noting, of course, we want you to speak with your employment law department, and we're more than happy to speak with your employment law department, because I'm sure there's questions as to why we're asking for certain bits of information, and we are more than happy to have that conversation.
Right. And in litigation, when we ask for it, it's covered by privilege, even though in 99% of the cases, a workers' comp defense attorney does not represent the employer. We represent the insurance company. Correct. Good workers' comp defense attorneys understand that the employer relationship is the one that we are trying to protect. If it is because we're getting referrals and it's an employment relationship that we have with the employer directly, and that's where we're getting the files from, then obviously that is now a situation where there are certain cases of privilege. But even if I only represent the insurance company has a fiduciary duty to protect their insured, and that is conferred on me. And I know that if I protect the employer, the insurance company looks good. And so the insurance company is happy with me because I made them look good. Or if, in my preference, our relationship is directly with the employer, then we are keeping things in mind that are important to you, like your reserves, your ex-mod, which are things that many, many, many defense attorneys don't even know what they mean, don't even know how they work. They don't understand that if we say at the beginning of the claim, worst case scenario, this is a life pension case and it's worth $400,000, that now an inattentive claims professional is going to set that reserve at $400,000 when there's no indication in the evidence that it's going to get there. Could it? Sure. But there's no actual indication of that. So why are we setting the reserves that high? Because that's money out of your pocket that you can't use for operations. Or why are we just letting things go for 2 years and running up the TD and hitting the 104-week cap? Because that kills your ex-mod if we can go fast and move things quickly. So those are the kinds of things that we and other good defense attorneys are focusing on for the employers, even if we technically represent the insurance company. So with that, I'm going to end our formal presentation.
That was more than a minute.
I'm a work comp nerd. It's not my fault. That's what happens. You get me talking about what we do and I'll talk all day. But if there's any questions, please pop them up. If there's, I see one, or I see something. Is there any way we can address employees who will not agree to sign anything, write a statement? Yes. on most forms, there is an option for employees decline to sign. In some cases, you can get them to check off on that. And in some cases, you can get them to sign the form having checked off, I decline to sign. But if you have a semi-intelligent and combative employee, then maybe they won't fall for that. But even if you have written on the form, the employee was presented with this document, refused to comment or signed by the or the supervisor or the HR professional that presented it on the day that it was presented, not a week later, not a month later, not 6 months later, retroactively saying, well, I remember that this happened back then, but actually filling that out in the moment, that's as best you can do in those circumstances. And we can actually get some mileage out of that. Obviously, it's better if the employee signs it, but it does help if you've got the supervisor signing off, I presented this, they refused to sign. In deposition, the employees will typically admit to that. Yes, I refused to sign because it was full of lies. Everything they said was wrong. Okay, but in order to know it was full of lies, you did read it, you were presented with it, and you acknowledge that now. You just refused to sign it because you disagreed. Well, yeah, okay. So that's the best you can do in those situations. And, it's good. It is certainly better than nothing. But, if you have a combative employee, then there's a red flag right there. All right. Any other questions before we wrap up and let you go back to your days?
I have a question
Okay.
about what's the best way to deal with a stress claim.
Stress claims are tricky. There are different things. If you are a staffing agency and you implement correctly and sanctioned by HR and Employment Council the termination after short-term assignments, if all of those short-term assignments are less than 6 months, you are immune to stress claims, because no stress claim is allowed if the employment is for less than 6 months. And that is an affirmative defense, and it is one that I can take to trial on day one and win. So if you have a way of proving that it's less than 6 months, absolutely, that's just a we win. If it is broken periods of employment, then we maybe win. But in other cases, it's hard because what they're claiming is, well, this guy said this and it wasn't nice. And so all of the documentation that you do, the employee statements, the supervisor statements, the coworker statements, that's how we can prevail on those. It gets really complicated, and we could spend a whole hour on stress, harassment, and hostile work environment claims. But I will leave you with the two most important things is take statements and document the evidence as soon as you know about it. And if somebody makes a complaint to HR, you have to trigger an investigation. And then where companies go wrong and when it turns into a claim is when you, for protecting the privacy of the accused, don't follow up with the accuser. And that's where it turns into an angry accuser who then goes out and gets an attorney, and the attorney says, well, you don't have anything for an employment law claim or a harassment claim or a discrimination claim, but have you met my workers' comp attorney? Because if you say that you need medical treatment, then we can get you $10,000 or $50,000 or whatever it is. That's where it goes wrong. So work with your HR people, work with your employment law people to find the appropriate way to follow up with the employee and let them know the results of the investigation to the extent that you can, because there are privacy concerns, which is why you've got to make sure that you're working with HR and employment law. But that follow-up goes a long way. And if you determine that there's no merit and that they're making it up and that they're the problem, then you either have to document that and take some sort of employment action because of it. If you can, check with HR in your employment law department, or you can just turn it around and show them some empathy and come up with some solutions. Maybe you can transfer them under a different supervisor, and you can say, well, we did the investigation and we didn't reveal anything that we can take action on. However, if you need to take a day off, if you need to be transferred to a different department, work a different schedule, be paired with a different team leader or a different coworker, let us know, and we can try our best to accommodate those kinds of changes. You're not going to be able to do that in every situation, but making the effort goes a long way.
One.
I'm hearing somebody talking in the background. I don't know if that's a question that we can't hear or if it is an accidental unmute. It was an accidental unmute. Okay. All right. Anything else before we go? Well then.
Well, before we end, I just wanted to say one last thing. Since we started with this presentation, I wanted to also conclude by noting that the information that we've given you today regards workers' compensation claims. A lot of these issues have crossover issues with employment law, and we would encourage you to speak with your employment law attorneys if there are any questions that you have. We do actually have an employment law department here at Perlman, Brown & Wax, and we'd be happy to set up a conversation with them, but we do want to make it clear that this information is solely related to workers' compensation.
Yes, obligatory legal disclaimers are always necessary because lawyers are the worst, but our lawyers are less the worst. So there's our marketing plug. And yes, we do advice and counsel both on employment and on workers' comp. So if there are things that we can help you with along the way, we would love to. Helping employers is why we do this. And I have another question.
Why would you have to?
What do I do? Oh, there was more questions because I didn't see the whole thing. Wait. Okay, second part of the last question. How can we enforce a no injury acknowledgement without stipulating an employer's pay on obtaining their signature? Similarly, how to enforce this acknowledgement in direct deposit situations? Okay, the first half of that, no injury acknowledgement without stipulating an employer's pay. I'm not sure what you mean by stipulating to their pay.
So in the example you gave, you talked about a staffing agency and the employees come in to get their paycheck every couple of weeks. And at that same time, they fill out a survey saying, nope, I'm not injured. Yes, I can perform my duties. But whether it's set up on direct deposit or, we don't want to get in a situation where we're stipulating their paycheck on getting that signature first so that we don't have employment law issues.
Right.
Well, how do we bring in that acknowledgement without it being tied?
I understand. And yes, that's a very good distinction because you cannot make signing the form a condition of receiving their check.
Yeah. And this is something that you would speak with your employment law attorneys about, like David had noted earlier, to make sure everything is in compliance and that they are reviewing these documents to make sure that it's good to be disseminated.
Gilbert, I think you got an intentional unmute. But so yeah, absolutely. The content of the form and how you present it and when you present it, that's where the difference is. If it's on the same page, I acknowledge that I received my paycheck and all of the workers' comp questions are on the same page, then it can start to look a little bit more like that. The phrasing can help, but you can put it on two separate forms and just be asking at the same time, although on a different form, I acknowledge receipt. And then on a different page, have you been injured? Do you need to go to the doctor? Are you feeling any pain or symptoms that would prevent you from doing your normal job? But by having it on two different forms, it looks less like you have to sign this or you don't get your paycheck. And the other thing you can do to get that out of their mind, just as a chilling effect, is when it's presented, don't make it seem like it's a condition. Do it second. Don't have, if they refuse to sign it, don't press that. Just hand it to them. And if they sign it, great. If they don't, it's okay, because you can't require them to. In those circumstances, and with direct deposit, it is trickier with direct deposit, especially if you're mailing the pay stubs, but you can still do it. You could just mail them the questionnaire, and you would phrase it a little bit differently. Instead of acknowledging that they haven't been injured, it's just a questionnaire of saying, have you been injured? That would say, if yes, return the form or call your supervisor. If no, sign here and send it back. Are they going to sign there and send it back? No. But then you can have your HR professional testify at deposition or in trial. This is our pattern and practice. Here's a whole bunch of examples of the forms that we get back proving that we actually do this, and we do it in every case. And that's going to be enough, even if the applicant doesn't sign it and send it back. So that comes into the phrasing, but the presentation, if you just give them their paycheck and then ask them to send afterwards, and have it on two separate pieces of paper, then that kind of solves the stipulation issue that you raised. But that's a very good point. So thank you for asking that.
Of course, thank you very much.
Now, scroll down here. Okay. Ergonomics and health. That's a good question too. So ergonomics is a tricky issue, especially with work at home. Now that everybody's working remote in office type jobs and things of that nature, ergonomics is a big problem. On the one hand, you don't want to incur the cost of buying everybody a fully outfitted and mechanically assisted office situation in their home, because it becomes cost prohibitive to have those remote employees then. But you have to know or allow people to request it. And, especially if there's a doctor's note, you have to accommodate. And you have to make sure that part of your remote work policy includes, to qualify for remote work, you have to have an ergonomically correct workstation at home, which means not sitting in your bed or sitting on your couch and setting up a TV tray with your laptop on it. This is not ergonomically correct. It's what I do at home, but it's not correct. And I just admitted to doing that on camera. So, if ever I file a claim saying my back hurts because of my homework, someone will send this to my boss and I won't get away with it. But in in-person work, it can be managed a little bit better. And you can acknowledge that, or have them sign an acknowledgement that they received the ergonomics and all of that. But those kinds of acknowledgements don't really help us so much. A photograph of their workstation helps better. So if you get a claim that I was injured because I had bad, posture, a photograph of this is where they worked, or this is where they currently work, that helps us better, because then I can show the doctor, well, look, no, the screen's right. They've got an ergonomic mouse. They've got one of those Ergo Wave keyboards and, all of that. That photograph works better. But keep in mind, just because somebody has an ergonomically perfect workstation doesn't mean that they don't sit like this. Right? So there comes a point where there's no way to protect against everything. But in that specific situation, having them sign an acknowledgement doesn't really help that much. But you can take pictures. That helps more.
Okay. Anything else? Let me, before you say yes to read a question,